How did Elizabeth Holmes deal with whistleblowers? In particular, how did she deal with Erika Cheung, who used to work at Theranos, who quit and was one of the whistleblowers to the Wall Street Journal? So we're going to take a look at that letter, and you decide. You decide whether you think that was your average cease and desist letter, whether it was proper, whether it was threatening, whether it was harassing. I watched Erika Cheung testify in the Elizabeth Holmes trial, and she talked about this letter. So I thought I would share this letter with you. Hi there, I'm Michele Hagan. I'm a legal analyst and a former prosecutor. I'm also, you may recognize me because I provided a lot of legal analysis on the Elizabeth Holmes trial. So I created this channel because a lot of you reached out and said, hey, Michele, where can we get more of your legal analysis? So here it is. So please leave your comments, your questions, and do subscribe. Okay, let me give you a little background in case you popped on this channel and don't know who Elizabeth Holmes is. So, Miss Holmes started a blood testing company. And in January of 2022, she was found guilty of 4 counts of fraud, basically making misrepresentations to investors. Turns out the technology didn't work according to many of the witnesses, and the jury found that she committed fraud. So there were 4 whistleblowers, and if you go to my previous video, I think it's called Texts Reveal Elizabeth Holmes Whistleblowers, you'll find out who those 4 whistleblowers are and who that investigative reporter is who blew the lid off of Theranos. So let's take a look at this letter that Erika Cheung got from Theranos. Okay, here's the letter, and I'm going to go through it with you. But so I apologize if these yellow highlights are annoying, but this is how I work. This is how I roll. All right, so I'm going to point out a few things, you know, as a lawyer looking at this, and I want to say something first. You know, it takes a lot of courage for whistleblowers to come forward. You know, in Erika Cheung, when she received this letter, I think she was in her early 20s, 20, 21 years old. So, you know, put yourself in her shoes and think about how this must have felt for her to get this kind of a letter. And also whether, you know, you think it's a proper letter. It's a, you know, what lawyers call a cease and desist letter. Not particularly a letter I would send, but I'll point that out to you. All right. So let's break this letter down. Let's take a look at it. This is a letter that Erika got from Theranos, from their lawyers. And this took place, if you go back to my previous video, you will see that it was January 26th when Sunny Balwani says to Elizabeth Holmes, text to her, that it was okay, I think it was okay to send the letter to Erika. Well, this is the letter they sent to Erika Cheung. Look at the date, June 26, 2015. All right, so let's go through it. Via hand delivery. Hand delivery. They didn't mail this letter to her. They had someone hand it to her. Okay. Redacted part. I didn't redact this. This is from the court. This is one of the exhibits from the Holmes trial. So I didn't do any of this redacting. This is just how the exhibit appears, all right? So let's go ahead and read it. Dear Ms. Cheung, this firm represents Theranos. We have reason to believe that you have disclosed certain of the company's trade secrets, there's that trade secrets again, and other confidential information without authorization. You see, this letter came out when Sunny and Elizabeth were figuring out who the 4 whistleblowers are. They figured out one of them was Erika Cheung. And if you go back and look at that video that I did, you will see that they were talking about getting their legal involved. This is their legal, sending her a cease and desist letter. Cease and desist means stop what you're doing. Don't be divulging any secrets, proprietary information about the company. And they're routinely sent. I don't know about this letter, but this is the letter they felt appropriate to send Ms. Cheung. So let's read on. We also have reason to believe that you have done so in connection with making false and defamatory statements about the company for the purpose of harming its business. In other words, they found out, Elizabeth Holmes and Sunny Balwani found out that they identified Erika Cheung as one of the whistleblowers. So they're trying to stop. They're trying to stop any more information coming out. They're trying to deter these whistleblowers from cooperating or giving further information. They want to silence them. They want to protect their trade secrets, any information that's proprietary to Theranos. All right, so they're saying, stop making any false or defamatory statements about the company. You are directed. These lawyers are directing Erika Cheung, a 20, 21, 22-year-old young woman, to immediately cease and desist from these activities, unless this matter is resolved in accordance with the terms set forth in this letter, in other words, according to their terms, by 5 p.m. Friday, July 3rd, so it basically gives her a week, 1 week. Theranos will consider all appropriate remedies, including filing suit against you. They're basically telling her they're going to sue her, right? Filing suit against you. They're going to consider it. As you are aware, during your employment at Theranos, you had access to Theranos trade secrets and other confidential information. Okay, I get it. They want to protect it, right? As a condition of your employment, you executed an at-will employment, confidential information, and invention assignment agreement, dated October 14, 2013. So approximately almost 2 years prior, in which you agreed not to disclose without authorization any Theranos confidential information. So what they're trying to do is they're trying to stop her from disclosing anything that's confidential, which I think you could say would be what Erika Cheung thinks about the technology, right? It's what she testified to on the stand. It's one of the bases, many of the bases for why the jury, I'm sure why the jury found Elizabeth Holmes guilty. So, under that agreement, confidential information includes, what does it include? What is she supposed to stop talking about? Right? Allegedly, right? Any non-public information that relates to the actual or anticipated business or research and development of the company, technical data, trade secrets, or know-how. Okay, does that include the fact that the technology doesn't work, in as many witnesses testified to? So how are you supposed to figure out what this means, right? I assume Erika Cheung didn't go to law school. Even I'm looking at it going, okay, what does that mean? All right, so indeed, upon the termination of your employment, remember, she only worked there for a couple months, I think up to 6 months. She figured out the skinny on what was going on and she quit. Indeed, upon the termination of your employment with Theranos, on or about April 16, 2014. April 2014, this letter was sent to her in June of 2015, a year later. Can you imagine? You quit, you've moved on, and you get a letter from a former employer that tells you to, I mean, this letter I'm sure would scare most people, right? So, you were specifically reminded and agreed in writing that those confidentiality obligations continued even after your departure. They're reminding her that she still needs to abide by that agreement that she signed, even though she's left. This is to remind her that she's not supposed to be disclosing information. Then they say, we have reason to believe that you have violated your confidentiality obligations in connection with your efforts to disseminate false and defamatory statements about Theranos for purposes of harming its business. Well, we all know that the jury didn't find those statements to be false or defamatory. Well, let me step back a second. We do know that the jury did find Elizabeth Holmes guilty of fraud. Okay, so again, this video is just my opinion. I'm curious to see what your analysis is, what your take is on this too. So don't forget to leave your comments and subscribe. But let's move on. The company is prepared to file suit against you to remedy and prevent further harm, reminding Ms. Cheung again that they're prepared to sue her. If you wish to avoid litigation prior to the deadline noted above, in other words, if we don't hear from you by July 3rd, the company is prepared to sue you. If you wish to avoid litigation prior to the deadline noted above, you must, not shall, not may, you must. Here are the terms. Here are the terms. Immediately gather and return to the firm. I guess that means the law firm. Immediately gather and return to this firm any and all Theranos confidential information in whatever form that remains in your possession. In other words, turn it all over. Are they referring to, are there documents that Erika Cheung provided to the Wall Street Journal? To other parties? Is that what they're implying? Now keep in mind, they just figured out within the last month who these whistleblowers were. Okay, 2. Oh, and by the way, PFM Depot refers to the PFM investor is the PFM Health Sciences Fund, which was one of the investors that Elizabeth Holmes was convicted of defrauding to the tune of $38 million. So this is stamped relating to a deposition that was given. Depot in that case. There was an earlier case in which PFM sued Theranos and settled. Okay, so this document is part of that proceeding, but it's also part of the Holmes case. It came in as a trial exhibit. All right, so anyway, she has to gather all the information. Now she has to identify and describe with particularity any and all Theranos confidential information disclosed by you without authorization or received by you since your departure for the company. In other words, tell us what you told anybody. Number 3, identify all persons to whom you have discussed and otherwise disclosed information. All right, tell us who you spoke to. We want to know. Number 4, identify all persons from whom you have received confidential information. So who did she get information from since she left? Number 5, agree to refrain from further violations of your ongoing confidentiality obligations and from making any false or defamatory statements regarding Theranos, its principles, or its business. So in other words, stop talking. Is that what that's saying? And these are their terms. This is the terms of the lawyers representing Theranos. This is what they're telling Erika Cheung to do, and if she doesn't do it, then she may get sued. Submit to an interview. Oh, okay, so you not only want me to turn over everything, rat out everybody who I may have talked to, but you want me to submit to an interview by outside counsel. Not by the people who sent me this letter, but by outside counsel. Among other things, your actions, your compliance with these directives, the false and defamatory information disseminated by you, and the steps you must take to ratify. So you have to, Erika Cheung has to submit, this early 20-year-old young woman has to submit to an interview by probably a bunch of lawyers regarding what she may have said or done regarding false or defamatory information. Okay. Number 7, So not only does she have to turn over these things, she has to submit to an interview. Now she has to execute an affidavit. And again, this is just my opinion here. Execute an affidavit under penalty of perjury. So they want to be able to use this against her. She says something different, right? Certifying your compliance with the items 1 through 6. I, Erika Cheung, agree that I will, that I have turned over all the information, I identified all the people, I refrained from blah, blah, blah. And the steps, okay, certifying your compliance with 1 through 6 and additional points. So in other words, whatever they decide to put in this affidavit, is that what that's saying? To be discussed with Theranos attorneys during the in-person meeting described above. You got to show up where we tell you to, and we're going to ask you a bunch of questions, and we're going to want you to sign an affidavit under perjury, penalty of perjury. Wow. You are also hereby on notice of potential litigation. Again, they're telling her she's under notice of potential litigation against you in connection with these matters. Accordingly, Theranos demands that you preserve all documents, tangible things, and electronically stored information potentially relevant. So Erika has to sit here and figure out, okay, what is it that happened a year and a half ago, or what are they talking about, and where do I have any information? And I have to decide what information is potentially relevant, including electronic files and other data generated by and or stored by computers and storage media, hard drives, hard disks, backup tapes, USBs, other drives, CDs, DVDs, etc. Or any other electronic data such as voicemail. We want your voicemails too. Your failure to comply with this demand can result in severe sanctions being imposed on you for spoliation of evidence or potential evidence. Be advised that, is that italicized? That we are also contacting others. Be advised that we're also contacting others whom we have reason to believe have breached confidentiality obligations and or defamed the company. So they're telling Erika Cheung, they're telling Ms. Cheung, hey Erika, by the way, we're also looking into other people. And I get it. It says a prompt response either for you or your counsel should be directed to my colleague. Sincerely yours. So I get it. Lawyers, that's what we do. We try to protect the interests of our clients. If our clients think that an employee is walked off or, with our information using our trade secrets, great, send a cease and desist letter. But I ask you, how many times did they mention the word litigation, lawsuit? So let's scroll back here. Imagine being Erika Cheung. She's left over a year ago and she gets this hand delivered. Not mailed to her, hand delivered. Hand. They could have mailed it to her. I wonder why they hand delivered it to her. So let's count. How many times? All appropriate remedies, including filing a suit against you. That's 1. Number 2. Company is prepared to file suit against you. That's number 2. If you wish to avoid litigation, that's number 3. Okay, let's see. You are hereby on notice of potential litigation against you. That's 4. Your failure to comply with this demand can result in severe sanctions. That's 5. I don't know. Do you think this is your typical cease and desist letter? What was the purpose of this letter, do you think? What was the purpose that Theranos sent this letter to Erika Cheung? And how would you feel if you got this letter? So, do let me know. Please leave a comment. Please leave your questions. I enjoy reading them and responding to them. Please do like, subscribe. Please subscribe. And do share this video. Thanks so much for watching. I hope this was helpful to you. And it's also good to see what a cease and desist letter, not one that I would send out. I'm old school. We don't usually, mention litigation 5 times or threaten to, I don't know about threaten, but mention that we're going to sue you. I'm just a different style. So anyway, thank you very much for watching. Please subscribe and please do leave a comment.